everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm Assistant Director of Networks with the Federalist Society. Today, we're excited to host a Courthouse Steps oral argument on Landor v. Louisiana Department of Corrections and Public Safety, featuring Meredith Holland Kessler. Meredith is managing attorney for the Lindsay and Moroun Religious Liberty Clinic at Notre Dame Law School, where she trains students in the legal profession as they work to promote religious freedom. She also represents clients in a variety of legal matters, with a strong focus on the clinic's litigation efforts, and oversees the clinic's operation. Prior to joining Notre Dame, Meredith practiced law in Washington, D.C. as an Issues and Appeals Associate at Jones Day. Our moderator today is Joshua C. McDaniel. Josh is the director of the Harvard Law School's Religious Freedom Clinic, where he gives students a hands-on, supervised experience representing a diverse group of clients in First Amendment and religious freedom cases. Before entering clinical teaching, Josh clerked for the Honorable Cormac J. Carney with the Central District of California and the Honorable J. S. Bybee of the Ninth Circuit Court of Appeals. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Josh, thank you for joining us today, and the floor is yours.
Great. Thank you, Marco. It's good to be with everyone, and especially with my friend Meredith, to discuss the Supreme Court's oral argument earlier this week in the Landor case. And I guess I'll start off by saying that although the Federalist Society takes no position on legal issues, Meredith and I in our respective clinics have taken positions on this case. Both of our clinics filed briefs in support of Damon Landor in this case. So take our opinions and views for what they're worth, I suppose. But to get us started off, I guess I'll just very briefly introduce the case. It's this case involves the right of prisoners to exercise their religious beliefs in prison, and in particular, what rights do they have under the Religious Land Use and Institutionalized Persons Act, which is a federal law that Congress passed to ensure robust protection for prisoners to exercise their faith, notwithstanding the fact that they are incarcerated. And this case involves some particularly egregious facts involving a Rastafarian prisoner, and Meredith will get into that. And the key question for this case is whether there is any remedy under the statute RLUIPA that Mr. Landor is entitled to. And this issue essentially, I think for conservatives and libertarians, it's this very interesting intersection of potentially competing principles. You have religious freedom on the one hand, and on the other hand, you have prison security and the need to do things in an orderly way in prison. You have the text of the statute, and there are a lot of interesting statutory text interpretation questions in this case, and competing views on when is text clear, when is it clear enough, when is it unambiguous, and then in addition to that, you also have questions about federal government powers and in particular Congress's powers under the spending clause to impose third-party liability. So to help us understand all of that and to work through all of this, I will turn it over to Meredith to maybe if you could start, Meredith, by walking us through what this case was about, and from there we can go on to dig in a little bit into the law.
Sure. So there's a lot of sort of legal background to unpack, but the factual background here is actually fairly straightforward. That doesn't mean it's not egregious, as Josh said, but it's a fairly straightforward fact pattern. So Mr. Landor is a devout Rastafarian. As part of his religious beliefs, he believes that he cannot cut or shave his hair. And so prior to the incidents that gave rise to this case, he had been growing his dreadlocks for nearly 2 decades. And then he was incarcerated with the Louisiana Department of Corrections, serving a 5-month prison sentence. And for the first couple months, his hair was accommodated, his dreadlocks were accommodated, despite a policy requiring prisoners to have either very short or shaved heads. I don't remember which. And then he was transferred to a new facility with just a few weeks left in his 5-month sentence. And at that facility was informed that he would have to shave his dreadlocks. And he handed the officers, the jail officials, a copy of a Fifth Circuit opinion. Louisiana's in the Fifth Circuit, saying that Louisiana's policy of failing to accommodate dreadlocks was unlawful. And the jail officials allegedly threw that decision, that paper decision, in the trash, and then strapped Mr. Landor down and forcibly shaved his dreadlocks. And Mr. Landor then served the rest of his sentence, which was just a few weeks, in sort of isolated, restrictive housing, and then brought suit under RLUIPA following his release, at which point he was seeking monetary damages for the harms he had suffered while he was incarcerated.
Yeah, that's great. One of the things that struck me to preview a little bit the oral argument was, notwithstanding some possible skepticism on the part of some of the justices, I think there were several comments during the oral argument acknowledging that these were really, really bad facts for the state officials and what they did, and a very, hopefully everyone can agree, a pretty clear-cut violation of RLUIPA, even to the point where the Fifth Circuit had already addressed this issue, and yet the prison officials were disregarding that precedent. So great. So Meredith, maybe you can now walk us through what do we need to know about the background law to understand what happened at the oral argument.
Sure. So we start in a familiar place for followers of religious freedom laws, where we go back to the Supreme Court's decision in Employment Division v. Smith, which is what precipitated the passage of RLUIPA. So prior to the Supreme Court's decision in Smith, the government, when imposing a substantial burden on religious exercise, had to satisfy a compelling interest test. And under that regime, under that First Amendment regime, an individual who suffered a violation of those rights, that was subjected to an unlawful burden, could seek damages and other relief under 1983 for those violations of the First Amendment. In 1990, Smith sort of changed the landscape of the law by subjecting even incidental burdens on religious exercise that arise from neutral and generally applicable policies only to rational basis. And so it lowered the bar for the government to justify those burdens in certain cases. So Congress, of course, responds. It responds first by passing the Religious Freedom Restoration Act, RFRA, which we heard about at the argument. And RFRA restores both the substantive protections of the First Amendment, meaning that it restores that compelling interest test for burdens on religious exercise, but it also restores the remedial provisions by creating a private cause of action for individuals to vindicate those rights. The Supreme Court then comes in and says that RFRA is unconstitutional as applied to states and local governments. It exceeded Congress's enforcement power under Section 5 of the 14th Amendment. And so then Congress responds again. And so we have this next law, which is RLUIPA, which is the one we're primarily talking about, which targets pervasive discrimination against religious believers in two fundamental areas, in land use regulation and the one at issue here for institutionalized persons who suffer burdens on their religious exercise. And again, in RLUIPA, Congress restores both those substantive protections as well as the remedial protections to vindicate those rights. And so to give you a little bit of the sort of nitty-gritty of how RLUIPA works, Congress, in passing RLUIPA, invoked both the spending and commerce clauses. It applies, its protections apply to programs or activities that receive federal financial assistance. And, again, like RFRA, it restores strict scrutiny for burdens on religious exercise. Like RFRA, it provides a private cause of action, where the phrase used is that appropriate relief against a government is available for violations of religious exercise in these two particular areas. And it specifically defines government to include officials and other persons acting under color of law. And I'll note one more piece of the statute that I don't think came up at argument, but I think was mentioned in the briefing, was that Congress also in RLUIPA created a public right of action. And so it enables the United States to bring an enforcement action that would lead to declaratory or injunctive relief.
Yeah, great. Yeah, super helpful. So, and I suppose we should just mention really briefly. So one of the big issues here is you have a Supreme Court from a few years ago in a case called Tanzan versus Tanvir involving a group of Muslim men who were put on the FBI's no-fly list, and the question there was, are they entitled to damages against officials in their individual capacity? And the Supreme Court ruled in their favor in that case and said, yes, not only can you, but the text of RFRA, the Religious Freedom Restoration Act, is very clear. The court went through looking at all the different pieces of the statute and looked also at the whole history of Section 1983 litigation that had preceded the passage of RFRA to say, yes, it's very clear that this remedy is included in the words appropriate relief when Congress used those words in RFRA. And so now in this case, we essentially have the same question that's being asked as to the identical language that appears in RLUIPA. And the language of the two statutes is identical. Really, the only difference between the two statutes is that's relevant here is the congressional power that's being invoked to support passing the law. So as you mentioned, you've got the Commerce Clause and the Spending Clause, but more often it's really the Spending Clause that is the focus of this, and that was certainly the focus of the Supreme Court's oral argument in this case. And
Josh, if I could mention
yeah.
one more background case that I think came up at our argument as well, and that might be helpful for everyone to have a little bit more foundation, is this Sossaman case. So prior to Tanzan, the Supreme Court had decided this case called Sossaman v. Texas, which was a RLUIPA case. So Tanzan is RFRA, Sossaman is RLUIPA. And it was a challenge by a state prisoner, and he was seeking monetary damages against the state and state officials. And this gets into the official capacity versus individual capacity distinction. And in Sossaman, the Supreme Court said that RLUIPA's authorization of appropriate relief didn't sufficiently, didn't unambiguously subject states themselves to monetary damages. They didn't waive their sovereign immunity to take on those suits for damages. And that was a 7-2 decision, I believe. So Justices Sotomayor and Breyer, I believe, dissented, but really turned on the waiver of sovereign immunity at that point. And in Tanzan, the court, obviously Sossaman would be sort of in the air if we're talking about what relief is available. And in Tanzan, the Supreme Court made very quick work of how Sossaman related to its interpretation of appropriate relief against individuals. And it says, in a paragraph, look, like Sossaman was dealing with a different context, and the language appropriate relief, as Sossaman recognizes, inherently context dependent. And so there we were talking about relief against a sovereign, and here we're talking about relief against an individual, and there the presumption is damages would be available.
Yes, yeah, exactly. And could you also say a word about what was at the time that the court granted cert in this case, what was the state of lower court approaches to this issue?
Sure. So it's not great from the perspective of Mr. Landor. So the circuits that had addressed this issue of whether RLUIPA authorizes damages against individual state officers had unanimously said no, that it doesn't, but they did so for a variety of reasons. And I think this got lost a little bit at argument. So some of them said, look, like the statute just doesn't authorize that clear enough. They invoke Sossaman. They say this just doesn't reach the sort of heightened clarity standard that we require for spending clause authority when Congress says, hey, you can have this money, but you have to require these particular conditions to be met. So some of them did it on the text, on the language itself. Many of them, though, invoked sort of a secondary question, which is like, regardless of what Congress said, can it do this? Does Congress have the authority to bind these individuals through its spending power? The government employees are not the ones who signed up to receive federal funding themselves. That was the state or the State Department of Corrections. So here, the Louisiana Department of Corrections, LDOC. And so there's this complicated, really thorny question over whether the spending power would authorize Congress to bind those, to put it in contract terms, which the spending clause is often understood as, those like non-parties to the contract between the state and the recipient of the funding. And so the landscape was unanimously that Congress couldn't do this, or that RLUIPA had not done this. And so when the court granted cert, sort of prevailing wisdom might suggest, look, like, why are they granting? If they agree, then why would they bother to grant cert, right? If the circuits are all getting it right, then maybe just sort of like let sleeping dogs lie, as we'll talk about in a second. I'm not quite sure that that's how the argument sort of played out, but that was sort of the situation on the ground.
Well, one might like to think that it was because of the amazing quality of the amicus briefs that were filed and were really persuaded the court. The other really interesting dynamic here was the fact that so the court, when it received the cert petition, called for the views of the Solicitor General's office, and in response to that, the Trump administration submitted a brief and very resoundingly urged the court to grant cert in this case and to reverse, and very much took issue with the approach of the circuit courts that had addressed the issue thus far. But it does raise this interesting question of if the court is sympathetic to Mr. Landor's position, it needs to explain why was it that all of these circuit courts along the way got it wrong. So with that, let's jump into the oral argument. I'd be curious about what are your overall takeaways from the oral argument? Does it look good? Does it look bad? Are you optimistic, pessimistic?
Sure. So I think, sort of picking up on what we were just talking about, I think one of the primary takeaways for me is that going into argument, I think, especially in the religious freedom world, generally, we sort of had this bit of optimism. We had, 20 amicus briefs from a really wide variety of groups and religious backgrounds, and sort of institutions with very different perspectives generally come in support of Mr. Landor. We had the United States come in support of Mr. Landor, and there was just like the fact of cert being granted itself. We had the Fifth Circuit, which is where the case came from, saying basically like, Supreme Court, you need to fix this. You're the one who can fix it. We think the language looks like it might authorize this, but we're not sure that it can. And so all of those things, I think, told sort of a story that suggests maybe this is, leading toward an easy and resounding victory for religious freedom. And I think, many sort of expected that. I think the argument betrays that that's not possible, but that it's likely much more complicated than that, right? And the question at issue really isn't a religious freedom, a First Amendment question as such. As you mentioned earlier, Josh, the substantive violation here really isn't on the table. The state officials, Louisiana, concedes that they are bound by the substantive conditions that RLUIPA protects. But the question really is one of remedies, and that gets to the spending power. And so those questions, I think, are really where the case is going to turn. And there's sort of really competing lines and sort of tensions. Again, as you flagged, Josh, that there's, sort of this instinct towards limiting congressional power, but that's in maybe competition with the really robust textualism that many on the court seem to favor. And so there's all of these like competing questions, and I'm not exactly sure how that's all going to shake out, other than it seems likely that, to me at least, that we're not likely to get sort of a neat unanimous decision. I think there's a lot of fracturing happening here. I think folks even who might reach the same outcome may do so for different reasons. And so I think relatedly, we have sort of a sense from some of the justices. I think Justices Kagan and Sotomayor and Jackson sort of tipped their hand, right? I think they, in their questions suggested, look, like Congress did this. This is what they said. This is what they meant. We know that. See Tanzin, see, 1983 and where the statute sort of pulled language from, and that this is squarely within the Congress's spending power. See, X, Y, and Z recent cases. I think the conservative leaning justices were a bit more of sort of, less certain in terms of maybe where the dividing line is, right? So I think some of them were really concerned about, like, is this even clear, right? And so Justice Kavanaugh asked a lot of questions about, like, I mean, surely Congress could have said this even more clearly, but is there enough here to suggest that it is clear, right? And so he was really, I think, focused on that first question of clarity. I think Justice Gorsuch to some extent as well, and saying, well, if Congress could have said, X, Y, and Z and didn't, does that mean that it's not clear here, but they could do it, they just didn't say the right thing? And then, I think a few others are really concerned about, regardless of what Congress said, regardless if there is sort of this consent and notice, again, to pick up on the contract analogy that's often used, can Congress do this? Can Congress reach the non-parties? And that's really a spending clause question. And so for sort of proponents of religious freedom, I think it's sort of important to realize that, this is an area where that sort of protection is coming up very directly against sort of other areas of constitutional law.
Yeah, thank you. So, and before we continue, I just wanted to mention to everyone in our audience, please, if you have any questions, feel free to submit them. We're going to do our best to leave some time for Q&A. So if we're discussing and we say something that prompts a question or makes you upset somehow, feel free to fire away with the questions in the Q&A box. So yeah, I would agree with your assessment. I think in speaking with a few colleagues that also listened in on the oral argument, and also just seeing some of the media coverage of it, I think the overall feeling was, I think if you were rooting for Mr. Landor in the case, that the oral argument did not seem to go so well, and it seemed like there was a fair amount of skepticism toward the arguments that petitioner's counsel was making in the case. But I am reminded of another, actually, I believe the most recent former RLUIPA case to be decided by the court, which is the Ramirez versus Collier case involving the death row inmate who wanted to have a pastor, as he was in the execution chamber, pray over him and lay hands on him in the final moments before he was executed. And if you listen to that oral argument, I think you might have had a very similar takeaway from the argument itself, where especially the more conservative-leaning justices on the court had some pretty direct questions and some difficult questions for the petitioner to answer in that case. But it ended up coming out as an 8-1 decision in favor of the petitioner in that case, that pretty resoundingly recognized the substantive right in that case. No guarantee that this case would come out the same way, but I would say I would characterize much of the conservative justice questioning as probing and not really revealing one direction or the other, which way they're going. But it is safe to say that they weren't jumping to the petitioner's counsel's defense in the same way that Justice Kagan and Justice Sotomayor and Justice Jackson were, if there was ever an opportunity. So within amongst the conservative leaning justices, did you see any kind of different philosophies coming out, or any fault lines amongst how they were thinking about these issues?
Yeah, so a few different questions I think came up that maybe suggest sort of different views of how this might shake out. I think one of the lines of questioning that I think, especially Justice Gorsuch and then the Chief to some extent were asking about was essentially sort of like, how far does this contract analogy go? Is it all
And really quick, just for those
Yeah.
who aren't really versed in spending clause, could you give us like a brief primer on what is the
Sure.
contract law analogy and how does it fit in here?
Sure. So the spending clause generally allows, Congress to spend funds in pursuit of the public welfare, of the general welfare, and it can offer funds to state governments, but it can condition the receipt of that fund on compliance with certain obligations, certain requirements, but it can't do that without giving clear notice to the states that they're essentially signing up for those obligations when they take the money, right? So there's this, the Chief was talking about sort of like, do we really have a deal here, right? So when it's a state taking money and the state is signing up to enforce the substantive protections of RLUIPA, the state knows what it's doing, or the state officials who sign the contract know what they're doing, right? And so there's this sort of contract analogy of the money isn't, coercing the state in some way, but they know what they're signing up for. And so where the contract analogy maybe starts to break down, or there's a question of how close we have to adhere to it in the spending clause contract is, can it reach these government officials, these individual government officials? So there's no question that there is injunctive and declaratory relief available, and that runs against, the official in his capacity as a state employee, right? So he is the one enforcing the obligations of the state and making sure that the conditions are complied with. But he as an individual is not the one negotiating with, if you can think of it as a negotiation, he's not the one deciding whether to take the money and sign himself up in an individual way for monetary damages, which is what would run against the individual in his individual capacity. And so you can think of them sort of as like non-parties in a sense to the direct contract if we're using that language. And I think the justices, several of them had questions about, okay, sometimes it seems like the petitioner's counsel and the government, the United States, were really heavily relying on the contract analogy, and they said, hey, like there is notice here, there is consent here, and then they maybe step back from it, right? And the justices were pushing on that of like, is it okay to go in and out of the contract analogy? Is it a perfect analogy? How strictly do we sort of adhere to it? And so I think that line of questioning suggests that there might be sort of different views on how valuable it is. The court, a couple of years ago, in this Tedeschi case, suggested that the contract analogy, only goes so far, but it sort of remains to be seen where exactly it ends.
Yeah, and at times the argument, to me at least, felt like I was in contracts class.
Yes.
You had citing to restatements and Justice Gorsuch in particular looking at agency principles to see, what do agency principles teach us about the potential liability of an agent acting on behalf of a principal and whether they can be liable for their own conduct. And a lot of discussion of contractual privity, and whether the contract that the state of Louisiana is entering into when it receives the federal funds, if there's some kind of chain of privity that can then carry over to the individual prison officials that commit the religious freedom violation. Do you think so? And I guess that kind of raises a question, which is, I think there are there are different paths that the court potentially could take in this case, if it wanted to rule in Mr. Landor's favor. What do you think? What do you think the options or the rationales are on the table that whether it be the contract law analogy or something else?
Yeah, so I think the path to ruling for Mr. Landor is probably the one that presents more of an uphill battle. So you can imagine in ruling against him, right, to sort of play devil's advocate for a minute, that it could be for several reasons. It could be for the straightforward reason that a few of the justices picked up on, just like Congress wasn't clear, right? We don't think that the language of the statute unambiguously, if that's what's required, subjects individuals to damages liability, individual officers to damages liability. And so that, I think, is probably like the absolute narrowest decision that's sort of available across both outcomes, across the board. That doesn't require the justices then, if they choose not to get into the more difficult question of like, well, Congress could do that, right? Or could they not? So even if they had spoken more clearly, and so we heard a lot about this from Justice Gorsuch and a few others, like, well, Congress could have said this, it could have said this. And so there's the backdrop question of, even if it had used the right language in a sense, would it have been able to do that? Both of those questions have to be answered in the affirmative for Mr. Landor to win. And so you can't separate them, but they're also distinct questions. And so I found at argument, often they sort of were bleeding together in a sense, right? And so I think there was sort of this presumption, and I don't know if it was intentional or not. I think that remains to be seen when the justices unpack their reasoning. But when we were talking about, well, surely there was sufficient notice, is behind that saying, and so long as there was, then Congress can do this. As long as these individuals did have sufficient notice, then we think that Congress can do it. Or are they just looking at the first step and trying to figure out, is it clear enough? And then we ask the second order question. And so I think those lines blurred, but for Mr. Landor to win, there would need to be an affirmative answer to both. Like, yes, Congress spoke clearly to this, and yes, Congress has the authority to bind these individuals.
Yeah, and I think then thinking about the flip side of if the court were to rule for Louisiana in this case and rule against Mr. Landor, I think you could really separate into two buckets the types of arguments that or the types of rationales that the court could look at. It could, I think that the more of a reach argument that has been made, and that some of the lower the circuit courts have adopted as their reasoning, is to say you simply, there just simply is no constitutional power of Congress under the spending clause to impose to regulate not the recipient of the funding, but to regulate someone who is not the recipient of the federal funding. That's just off the table. And so really it doesn't matter how clear the statutory text is in this case. It could have even gone further and could have specifically spelled out individual officers can be sued in an individual capacity for damages. And under that reasoning, that still would not be enough because they're not a funding recipient. And essentially that would mean that Congress just doesn't have that authority under the spending clause. It would need to look to some other some other enumerated power in order to write such a statute. The other argument is assuming, well, Congress could conceivably have the power to do this under the spending clause, but as part of the spending clause analysis, it needs to have a clear statement. And the statement here just wasn't sufficiently clear. And there were a lot of questions along the lines of, well, how can we say it's clear if virtually every circuit that has looked at this has scratched their head and said, we don't think it's super clear? Is it then really fair to expect Louisiana, when it accepts the funding, and these prison officials, when they accept employment with Louisiana, to say that, yeah, the statutory text is clear in this case? I don't know if you have thoughts on that.
Right. So I think sort of the unanimity with which the circuit spoke to the clarity question is actually overstated. So several of the circuits have said, we think the text is clear, or at least suggested it, right? If they didn't come out and say definitively it is clear, they said, look, the Fifth Circuit said, look, it surely suggests a damages remedy. The Eighth Circuit did in fact say that the language would be sufficiently clear. But then came to this contract analogy and said that spending clause just doesn't authorize it, like you're saying. And so I think that got lost, that argument, a little bit. I don't think, the repeated questions about like, how could it possibly be clear if everyone said it hasn't been clear? It's like, well, that's not really what they've said, right? And so I think that is important to keep in mind. And an interesting line of questions on this, as well as Justice Alito was asking, both sides and the government, sort of what is the relevant date from which the clarity sort of test runs? And so, I think, what he's getting at, I think, is that, so Tanzan, obviously, the decision we talked about, the RFRA decision, helps make this textual analysis easier, right? Because we now have an 8-0 Supreme Court walking through the exact same language. And we know from that decision, it was extremely precise. It was an extremely, diligent textual analysis, but it wasn't sort of labored. It wasn't a hard conclusion. And so it really does leave the reader with the impression of like, surely this is what the language says. And so if now we know that after Tanzan, then has the clarity sort of been reimposed in a sense, if the funding has been received after Tanzan, if a state official would have known about that. And so I think that's an interesting question too. Obviously the statute sort of always meant this, but is it now clear because we have this other other information?
Yeah, and so I have an observation on that, and maybe we'll tie this into a question that we received in the Q&A. I thought it was interesting that, and it was almost really easy to not notice this, but at the tail end of Louisiana's argument, Justice Alito was asking this question again about what is the relevant date that we look to decide whether there's sufficient notice. And one of the things that he was keen in on was the interesting timing of this case, where the court decided the Tanzan case, and I think it was something like 18 days after Tanzan was issued was when this incident with Mr. Landor being forcibly shaved happened. And so Justice Alito's point, which I think is an interesting one, was maybe it matters what the relevant date is, and is that date before Tanzan? If you think that Tanzan being issued is relevant to whether there's clear notice, which definitely is not a for sure thing. Maybe it depends on what was the funding received by Louisiana before Tanzan, or was it received after? And at one point in the argument, a point was made, well, the federal funding is often received on an annual basis, so maybe it wasn't received during that short 18-day period of time. But then at the tail end of the Respondents' Council's argument, they conceded, well, one of the interesting things about RLUIPA is that it's not tied to any particular funding program. It's triggered when any type of federal funding of any kind is received by a state, including Medicaid, and maybe that's even happening monthly, if not weekly, by each state, and which would seem, if Justice Alito was trying to pull the thread of arguing that this timing, and especially the fact that you wouldn't have had federal funding received between Tanzan was decided and when this incident happened, may have actually been kind of factually incorrect, because maybe federal funding, according to that concession, was received during that brief interim time. But so the question that we have here is, what do you make of the idea that our RLUIPA funds, they're not tied to any program specifically? And does that mean that you could deem RLUIPA unduly coercive? Or put another way, do you think that Medicaid funding to the state could be tied to RLUIPA requirements? Or do you think a prison system could reject funding without the state thereby undermining that argument? So I take kind of the general answer to be, it's kind of difficult for a state to not receive some kind of federal funding from the government. And so does that raise questions about the general constitutionality of RLUIPA as a spending clause statute?
Yeah, so I think at least in this particular case, the substantive obligations aren't at issue at all. So Louisiana has conceded that LDOC has conceded that its officers, the state and its officers are bound by the substantive conditions of RLUIPA. They're not taking issue with that. They're only taking issue with what remedy is available when those conditions aren't met. And so at least in this particular case, that question isn't being raised. And I think, I haven't seen that argument being litigated in lower courts, or at least like gaining much traction in lower courts as far as I can tell. And so I would say it's, sort of descriptively probably unlikely to sort of win the day, but it's not to say it's not an interesting question that may have come up or come up in the future.
Yeah, so there was a Supreme Court case in 2005, I believe, Cutter versus Wilkinson, that addressed the constitutionality of RLUIPA, but focusing more on whether RLUIPA was consistent with the Establishment Clause. I don't believe it got too much into the spending clause basis. So I would say it is an interesting question. At the same time, and I think this was raised in the oral argument itself. I don't think that RLUIPA is alone in being this type of statute. There are a number of spending clause laws on the books that operate similarly. And one of the important things that came out in the briefing and argument in this case was the fact that it's not like applying RLUIPA to permit individual capacity damages would be a very novel thing, because you actually have a number of examples of other spending clause laws, including in bribery contexts or the federal the FCA, where it's pretty clear that Congress has used its spending clause authority to impose liability on third parties. My question, Meredith, for you would be, what are your thoughts about the potential ramifications for this case on spending statutes more generally? Do you think is a ruling in favor of Mr. Landor in this case, is that going to upend things? Is it going to call into question longstanding interpretations of other statutes?
Yeah, I mean, I think the devil's in the details. I think from the argument, we know that both sides are at least claiming that will happen, right? That if you rule for the other side, you're going to upend X line of cases. I think the devil is in the details, because I think it would probably be helpful to have a sense of sort of what would be the outer bounds of what Congress could have said. And what I have in mind is, there was lines of questioning about, okay, so what if Congress had said, state, you're bound by the substantive obligations of RLUIPA, and you have to put in your employment contracts that individual officers will be held individually liable for damages if they do this. And then there's a question of, okay, is that notice sufficient? But I think it also raises other questions about, well, what if the state has to impose that sort of some sort of liability structure itself, right? Maybe it doesn't go back to the cause of action that's in RLUIPA itself, but that the state has to have some enforcement mechanism there, right? And then the obligation is binding on the state rather than on the individual. And those sorts of lines of questioning, I think, the justices had competing views over whether is that meaningfully different, right? If what we're saying is, hey, states, you need to make sure that this happens, you need to make sure everyone is aware that it's happening, is it really meaningfully different, sort of what enforcement mechanism you pick up? And so I think it sort of depends on how the issue is framed. There's obviously very competing views of whether this even is a non-party, right? And so there was to your point earlier, all of these questions about, well, is there some sort of privity here, right? Are they in a sufficient relationship with the state such that the obligations sort of trickle down in a sense? And so I think it will depend on how the court frames sort of the factual scenario of what's happening here. And again, we heard a lot about hypothetical questions of, okay, well, what about just reaching general members of the public, right? And we've seen that to some extent with the criminal liability, although in the bribery cases, although there's some distinctions that can be made there. But does this mean that then it can reach general members of the public? And there was some resistance to that notion as well. And so I think it really is going to come in the framing of sort of the factual description of what is happening here. And that will sort of determine which line of cases it sort of more squarely falls into.
Yeah, and I think were the court to rule in Mr. Landor's favor in this case, I think there's two approaches to the spending clause that the court could take. One would be to just say, look, this whole contract law analogy has gone way too far. It was really the only idea of it was when we were first kind of saying the state needs to be put on notice when it receives the federal funds, what it's getting, what it's agreeing to at that time. Sure, there's a contract law analogy there, and it helps to explain why we do that. But we really shouldn't be importing the whole restatement of contracts into our spending clause jurisprudence and having all of the nuances of that in terms of assumption of liability and contractual privity and all the rest be dictating how we think about spending clause authority, especially given that you have to layer on top of the spending clause authority Congress's broadening necessary and proper authority, which the court has pointed to in a number of these spending clause cases, like the Sabri case that was mentioned, where the court said, look, the necessary and proper clause does some work here, where Congress can ensure that it's maintaining the integrity of what it's spending its dollars on, and it can ensure that it wants to make sure that it's operating with an honest recipient, or in this case, it could be a rights respecting or not a rights violating recipient. So that's one approach. The second approach, and this is I take it to be the narrower approach, and something that Mr. Landor's counsel really focused on in this case, was to say, no, actually, let's take that contract law analogy and let's work within it. And here we don't have to discard the contract law analogy, because we can try and make a contractual argument that we're not talking about general members of the public. We're talking about employees of the state who, when they agreed to be employed by the state, did so knowing that RLUIPA is on the books and knowing that the state is subject to RLUIPA as a federal funding recipient. And so through the combination of those things, there's some kind of contractual privity, which seems like a nice narrower way to approach this, but also at the same time seemed to cause a little bit of there was a little bit of questioning on the part of some of the justices in terms of does that exactly work right under contract law principles, and maybe that's just kind of a risky proposition for the court.
Right. Right. And on the first path that you laid out, the necessary and proper addition, and that was really a focus, I think, of the United States argument yesterday, that really helps get Congress all the way there with imposing this individual liability. And I think, underlying that is sort of the idea that the substantive scheme here is really only so effective without monetary damages. And so individuals who suffer violations in prison, it's often too late for injunctive or declaratory relief to be sort of any use to them. And so there's an effectiveness to the scheme that is really increased by the availability of monetary damages, so that claims can't be mooted out if the prisoner is released or intentionally transferred, or unintentionally transferred, right? It just happens all the time. And that renders those other forms of relief essentially ineffective. And so the availability of monetary damages becomes, pretty critical in this particular area for allowing the substantive conditions to be borne out.
Right. Okay, we have another question here from the Q&A, wanting to know if 42 USC section 1983 would provide any remedy in this case. And I think there might be two ways, two things that that question might be getting at. One would be, is there like a First Amendment type claim that could be brought? And I guess another related question we have here is related to that is, does Employment Division versus Smith rule out a 42 USC section 1983 claim? There's a separate interesting question also, I think, of putting aside the First Amendment. It is pretty well established that you can go after officials in their individual capacity under Section 1983. And Section 1983 it essentially creates a remedy for a whole host of federal laws. And you had the Supreme Court just recently in the Talevsky case recognize that you could invoke Section 1983 to enforce a spending clause statute. And so maybe if RLUIPA on its own is not sufficient, is there some way that you could bring an RLUIPA claim through the vehicle of a Section 1983 lawsuit to achieve that remedy? So I realize there's kind of the two paths that I laid out for you there, but curious to hear your thoughts.
Sure. So on the latter, so the Talevsky decision, as you said, does sort of allow in fairly limited circumstances, and it was a pretty splintered decision, allow 1983 to be an enforcement action that would allow for individual damages against spending clause legislation. I suppose we don't know how that would play out with RLUIPA, but a critical part of that decision talked about the private enforcement from 1983 needing to not be sort of inconsistent with the statutory scheme that was laid out in the underlying spending clause statute. And so it seems maybe odd, I might sort of be overreading this, but it would seem odd if the statute itself has a private enforcement mechanism and it doesn't allow damages, then are we sort of upending that? Are we causing an inconsistency if we allow 1983 to be sort of a workaround for it?
And on that point, Justice Kagan seemed to return over and over again to Section 1983, but it wasn't to really invoke that creative idea of using the Section 1983 claim itself, but really to just make the point that in Section 1983 world, it's fairly common for that. We've recognized in Talevsky, you can enforce a spending clause law, and we've never had these questions about notice to third parties in those types of cases, even though that issue would presumably come up in those cases. So, which seemed like a fair point to me.
Right. And I think heavily invoking the 1983 piece to just give meaning to what the language on its face means when we're talking about damages against individual officers, defined in the exact way that 1983 defines government officers, right? The language is imported from 1983 into RLUIPA. And so I think that obviously is relevant to the textual analysis as well. On the former question, so I think Justice Alito touched on this sort of in passing at argument, was he asked about sort of what was the nature of the policy here? So was it a universal policy that all prisoners had to shave their head? And I believe the answer was yes. And so to me, that suggests that, Justice Alito was working to confirm that this was a neutral and generally applicable policy that incidentally burdened Mr. Landor. And so under Smith, that would be one of the cases where the protection is lessened. The government only has to satisfy that burden by rational basis rather than strict scrutiny because it's neutral and generally applicable. And so we end up in this world where Smith leads to lesser protection than the RLUIPA scheme, which restores the pre-Smith substantive scheme, then RLUIPA would offer as a substantive matter. And so if that is true about the way that the haircutting policy works, then 1983 would depend on the terms of the First Amendment substantive protections. And so if it's neutral and generally applicable, then Mr. Landor likely would unfortunately be out of luck.
Yeah, and related to that point, Justice Barrett had she kept bringing up again, the facts here seem egregious. She wasn't really tipping her hand about what she thought about the ultimate question in this case, but she did have some questions about would state law provide some type of remedy in this situation, and the counsel for Louisiana explained, yes, there is a kind of state mini RFRA that could potentially apply in this case, but then as was pointed out in rebuttal, as a number of other states do, Louisiana, although it does have this compelling interest test that it adopts for state actors that is similar to what we see with the Federal Religious Freedom Restoration Act, it modifies the standard in the prison context so that you don't have that same strict scrutiny test in that context. So for that reason, um, you might have a viable or a potential state law claim there, but it would probably be more of an uphill battle just because of that change in standard in the under the state law.
Right. And I'll just add one more, while we're talking about sort of other potential avenues for protection, I'll add, in his opening, the Solicitor General for Louisiana flagged like Congress could solve this problem by fixing the original Sossaman question that we had talked about, right? So this is the waiver of sovereign immunity question. And so in his opening, he said, look, like if Congress meant to have states be on the hook for monetary damages, then it can do so by imposing that waiver unambiguously. And so there are sort of, that's a big ask, right? For a lot of reasons, but there are potential avenues to sort of solve the problem in a sense, whether they're sort of meaningful opportunities for success to solve the problem, I don't know, but they're at least sort of theoretically available.
Great. Well, I think that's a good place to end. I see we're getting pretty close to the end of the hour, but just wanted to thank you, Meredith. I learned a lot and really appreciated your insights. And with that, we'll be adjourned.
Thanks, Josh.